Elena, let's talk about, if I'm an executor, well, once again, sticking on the whole cross-border theme, but let's say I'm that Canadian moving to the States, was really left some assets or, in the US, but I'm still a Canadian resident. Like, talk to me from a tax perspective of a Canadian resident. Like, I have not moved to California yet, so I'm that Google executive, right? But I've inherited some assets in the States. How do I go about doing that where I'm going to be moving to the States, but I have not yet already?
Okay, so your favorite uncle has passed, and now you got what did you get? You got a piece of real estate, or you got portfolio? Like, we actually need to go on an asset by asset basis to
Okay.
figure out what's going on. Also, we need to know who is the executor or who is a trustee of the estate, right? Because if the trustee or executor is a U.S. resident, then it's a U.S. estate, and you're just gonna get, the distributions.
Let's say it's
As a
me though,
beneficiary.
as a
Oh, you
Canadian.
are. Oh
Yes,
my
let's say
goodness,
me.
you're gonna be busy, Grant.
So
You're
I'm
gonna.
I'm the executor. I'm
Okay.
also obviously inheriting some of this stuff from the family, but I'm in the process of moving. So I know
Oh
that's a
boy, don't do it. Don't
sticky
do it.
situation. Okay, all right, okay. But I have to. I'm getting relocated to California for Google, right?
Ask
So I know
ask
it's
for an extension.
okay. I'll go to the boss.
Well, it's quite a process, I can tell you,
Yep.
because it's complicated. The reason what causes that complication is because once the majority of the trustee or the sole trustee is a Canadian resident, then the estate becomes a Canadian resident estate. So it doesn't matter that your uncle is a US resident and all
Yeah.
the assets in the States, the trust itself, the testamentary trust, the estate, is another Canadian resident. So what will happen is that you have Canadian tax obligations, reporting obligations, and tax obligations, and you will have to deal, with a U.S. lawyer because there's still going to be U.S. probate on those assets because the assets located in the States. So first of all, you need to figure out. I mean, again, we can talk on that subject for days, but very high level, you need to figure out how those assets, the assets of the decedent, were held. Were they in a living trust or they were held outright? Okay, because that will change the taxation and reporting and stuff like that. So if they were held in a living trust, what you would like, Grant, I mean, I have this story which comes to my head, and it's it's kind of bad. So what you want to do, you don't want to inherit those assets outright. You don't want to be a personal individual beneficiary of the living trust. You want your personal trust be a beneficiary of that living trust.
Okay.
Okay, and the reason why I'm suggesting that is because from the US perspective, when we have a living trust, the assets are commuting back to the owner on death, okay, and they get a step up in basis, okay, as if the owner held them outright, as if your uncle held them outright. From the Canadian perspective, trust is considered a separate taxpayer, all right, which means that when you are inheriting assets as an individual, you're not gonna get a bump up in basis on the day of uncle's death for Canadian purposes. If the uncle bought, Johnson and Johnson in 1978, okay, that is gonna be the basis of the shares you're gonna be getting from the Canadian perspective. So it can become quite complicated. So what we've been, if we're catching clients on time, we actually had a case just very recently. We had to keep someone on life support to make sure that the will is properly executed, okay, or the trust agreement. So we had to substitute the individual beneficiaries with personal trust beneficiaries, okay, just for that particular purpose. But let's go back to, kind of a more high level discussion. Sorry, I tend to go into minutia here. If you need to go on an asset by asset basis, and what will happen is, you need to determine who has the first right to tax those assets. Okay, so when it comes to U.S. real estate, U.S. will have the right to tax. Canada will have a secondary right to tax. When it comes to securities, it's a personal property. Canada will have right to tax, and U.S. will not have right to tax those assets, and so on and so forth. But again, as a trustee, you will have to do a lot of there's just a lot of work on your shoulders. To go through the process, to be compliant on both sides of the border, to get the clearance certificate on both sides of the border. So if I were you, I would clearly not take the assignment at the same time, the California assignment.
Well, okay,
so why don't I jump in on at least one other asset, at least that's a common one, just as an FYI. So it's in the United States, they have a different type of retirement account that we have in Canada called the IRA, or individual retirement account. The one major difference, and again, this has been kind of and there's a major change that happened recently, but you can name almost anybody as your beneficiary of an individual retirement account, including your neighbors. Your uncle, in this case, could have easily named you as a beneficiary of his retirement account. And also, if you had a government-sponsored plan, let's say you had a 457, or you had a 403B deferred compensation plan, you can name all sorts of people as beneficiaries. They don't have to be next of kin, right? The way that we do in Canada. So it can be a little bit different. So they have enhanced planning opportunities, which were amazing, and they're less good now, but they were still really good. So in the end of 2019, the U.S. federal government came out with a new proposed change to increase the age at which you are required to start withdrawing from your retirement accounts. That did so at the expense of really eliminating, or frankly making it a lot harder to deal with a retirement account on an inherited basis. So when a person passes away with an individual retirement account, it creates what's called an inherited or a stretch IRA account, which means that a beneficiary can then take over ownership of that account, still maintain taking money out as you need it to, but you can really defer that tax for a lot longer. You didn't have to take a giant hit. So recently, at the end of 2019, the government in the U.S. changed that to say it could be almost in perpetuity until you depleted the asset. Now you have a 10-year window in which you actually have to take out all the money within 10 years. It's still better than we have in Canada, but it's still there.
Right. It's interesting that you brought up about the beneficiaries. As long as they're humans, they can be beneficiaries. And in fact, they don't have to be.
My dog can't be the beneficiary.
Well, it depends how much human the dog is. But what interesting is they don't have to be a named beneficiaries on the IRA. Okay, they can be actually beneficiaries through your will. It's like literally U.S. government, going through and saying, okay, so who is going to at the end of the day be entitled to your assets? What you need to be aware of from the Canadian perspective is that if you grant is a beneficiary of your uncle's IRA, is that you would have to you would need to notify the bank that it's you, provide them your tax ID. Hopefully you have one, and if you don't, you need to apply for one. You're not going to be eligible for Social Security number, so you will have to obtain an individual taxpayer identification number, ITIN. And then the custodian will withhold 15% at source tax and pay you the balance, okay, of that IRA. And if you are collecting the lump sum distribution. Okay, so very often custodians actually holding back 30%. Okay, they're foregoing the treaty reduced rate and they're just doing it under the domestic law. So what it will mean that you would be responsible for filing your own U.S. tax return later to collect the over withheld 15%. You will be required to report the distribution on your Canadian return at gross, and you will only gonna be eligible for a credit for the correct 15%. So if the bank holds back 30% and you just don't want to be bothered with filing return to get 15% back, and you say, I'm just going to report the entire 30% as a credit in Canada, CRA will tell that you gratuitously gave the US government 15% because the credit will be limited to the correct 15% under the Article 18 of the treaty.
Okay.
So
So
just sort of one more thing just on that note, because this is such a loaded topic. We see it all the time.
It is a loaded topic.
It's a really it's really how deep down that rabbit hole do you want to go. But what you see is that there's a lot of tax planning that people do for postmortem purposes in the United States that frankly isn't as applicable here in Canada. Like they use trusts very prevalently in the US. We don't use them as commonly in Canada by comparison, just due to the fact they're not very tax favorable here. We've run into numerous circumstances where, an individual named their trust as a beneficiary of their retirement accounts. And it's perfectly good planning
in
for
Canada or in the US?
In the US. They named their trust as a beneficiary of their retirement account in the US, and instead of naming their actual beneficiaries directly by name. And that caused a giant problem, especially when you have, in your case, Grant, a non-resident beneficiary of a trust. So because you can actually roll the funds directly into the name of the beneficiary in effectively creating what's called an inherited IRA rollover. That's totally doable. But when you put a trust in the middle, that really complicates things, because now you have what's referred to as a two-step rollover, which not every institution A will allow, and B, it becomes very complicated because now you have effectively a game that you're playing with the IRS and trying to make sure that who is actually the beneficiary, and of that, then they have to make sure that the trustees are not going to come back and try to claim anything else on the trust and try to take the funds away. It can become a real nightmare, and we've gone through a bunch of these things on our end as well. And we typically advise that some things are really good planning for American residents, but if your beneficiaries are outside of the United States, you really want to make sure you're getting really good cross-border counsel to see whether or not you set your accounts up appropriately. Otherwise, you could be running into nightmares where it could take you months, if not years, to try to affect that what your wishes were.
So on that note, let's assume that my uncle had an IRA and he left it to kind of two ways. If he left it to the trust, right, which then would be part of my job as the executor to work through the estate and all of this, but I'm still Canadian. What happens then? And then number two, if he didn't leave it to a trust and he wanted to roll it over to me directly, as you were saying, how would he do that if I'm not even an American resident?
That's a good question. So the latter is the preferred method because it's cleaner, simply because he can actually name you as a beneficiary in any of his documentation, or as Elena mentioned, in his will. And you could then become effectively the future owner of that asset. And you could either create what's referred to as an inherited IRA, or stretch IRA under your name and then maintain a tax deferral for a period of time, or you could take a lump sum like she mentioned and pay the withholding tax. That's option two. Option one,
and I'm able to do that as a Canadian resident.
Correct. So you have to file for an ITIN like she mentioned before. Make sure you have a tax identifier number, but you're legally entitled to have that asset even though you're not an American resident. So that's okay. Yep. If there were distributions being paid out by your uncle to himself, you'd have to maintain that going forward. And there'd be in a percentage that you have to take out every single year. It's intended for you to try to take out majority of the money over your life. It used to be awesome because you could be able to stretch it out for the period of your life. Now you can do it for 10 years as of the end of 2019. So that's one point. But had he named his trust as a beneficiary and then you the beneficiary of the trust, that complicates things, because then you have to create what's called a pass-through type situation where they have to look through the trust to ultimately see that you're the beneficiary. And some institutions have a problem with that. It opens up increased liability. It opens up a lot of sort of a whole other can of worms. So in order to help potentially minimize your probate tax situation in the US, you potentially subject you, Grant, to income tax in Canada.
Gotcha.
Which is a whole other can of worms. So
So that's good. I think it's important for any Americans to just or Canadians to know that all of this stuff really, guys, before they go down there. But I wanted to kind of continue with this example of
Grant,
me.
can I interrupt you? So you know where we see that quite a bit. It's not as much. I mean, inheritance is a big part, but considering how mobile Canadians are, right? We see that a lot when Canadians used to work in the States. They had 401ks, they have IRAs, and then they're coming back to Canada. And then, they are now the owners of their accounts, and they are passing, because that's another layer of complications, right? So I would say when it's just a pure inheritance, that, I mean, it's quirky, but it's not as bad as actually passing with the IRA or 401k.
Okay.